Good morning and welcome to the South Dakota Workers' Compensation webinar. I'm Sean Lyons, Executive Director of the South Dakota Retailers Association. First, some information about our association. The South Dakota Retailers Association is a 3,900-member statewide association, and our primary mission is to represent retailers in the legislative and regulatory process. In addition, we provide information, offer training for food service and alcohol licensees, and provide member services. Those include credit card processing, workers' compensation insurance, dental insurance, and data security. We also have an agreement with a labor law firm that allows our members to get answers to employment law questions from an attorney. Now that you know a little bit about us, I'll introduce you to James Marsh, who is presenting today's program. James is the Director of the Division of Labor and Management for the South Dakota Department of Labor and Regulation. He's held that position since 1995. James is a graduate of the University of South Dakota Law School in 1986 and received his Bachelor of Arts from Dakota Wesleyan University in 1983. We work with James often, and he is a great resource to our organization and members. Two notes before we start the presentation. The phones of all attendees are muted, so we won't be hearing background noises. Second, we'll have a question and answer period at the conclusion of the presentation. If you would like to ask a question at any time, just go to the panel on the side of your screen. You may need to click on the orange arrow to maximize the panel. Where it says type message here, type in your question and then click on send. At the conclusion of the presentation, I'll read the questions out loud, and James will provide the answers. With that, we'll now turn the presentation over to James Marsh. James, good morning.
Good morning, Sean, and thanks so much to you and to Donna and the retailers for putting this together for us and giving me a chance to talk to the group. We'll be talking again about workers' compensation today. I hope you find it valuable. When it comes to this sort of presentation, I want to say that I try to keep it as unlegal as possible, at least avoiding legalese, but there are going to be instances in which we have to stray into that a little bit to make sure we're clear. But before we go any further in the area of workers' comp, we have to talk about the grain of salt. Every lawyer worth his salt does a disclaimer. Mine would be that just because Marsh says something in a presentation doesn't necessarily make it so. I would recommend that any employer that is listening today, if they have issues about work comp, they can run those things by us, but ultimately should speak to their private attorney. They can give them more authoritative opinions that they're paying for. With that said, the first thing out of the chute is talking about employers. Workers' compensation only applies to employers and employees. And under the work comp law, an employer is one who uses the service of another for pay. There has to be an actual contract for pay, forming a quid pro quo relationship. I pay you money, you do services for me. There are instances in which a general contractor becomes what we call a statutory employer if the subcontractor has no insurance and the sub's employees are injured doing work connected with a general contractor. So if I have a plumbing contractor working with me, plumber happens to have some employees out there that are performing services, and the plumbing subcontractor doesn't have the insurance, that plumber's employees can make a claim against a general contractor for coverage, forming what we would call a statutory employment relationship. The employee is the one who provides the services. We include certain kinds of people such as government volunteers, firefighters, rescue workers. One would be of interest to you possibly is students. If they're doing like a VOTEC program, work experience after they graduate from high school, but going to VOTEC, doing an off-campus work experience. In those cases, it's presumed that the school will be the employer of this particular person. But if the employer provides, which the work experience is being done, provides pay or workers' compensation coverage, they become the employee of the employer during the time they do the work experience. Corporate officers are employees, even if they're owners, but they can be opted out of coverage by law. You want to do that before any payments start being made. And there's no particular form for that. It seems like each insurance company has their own way of attending that requirement, but it does have to be communicated to the insurance carrier pretty early on that an officer should be excluded. The main thing that comes up with that lately is the issue of contractors versus employees. Do I have a contractor working for me or the employee? Now, the two traditional tests work comp has used in those settings are right of control and whether a person is engaged in established trade, occupation, or business. What degree does an employer, when it comes to the relationship with the worker, set the how, and when it comes to right of control? It's not enough that we say, I want you to do this job for me, but getting specific about the manner in which it will be done, when it's going to be done, how long it's going to take, how much the person is going to be paid. And the established trade, occupation, or business, person really does have to identify themselves as being in a separate entity from the person they're working for. I digest this into a more recent formulation. I've actually used this version of it for about 20 years, but the feds, through the United States Department of Labor's Wage and Hour Office, have adopted it to my satisfaction. I call it the hiccup test. It's not a be-all or end-all for you, but it is a way of being able to say, you know, I'm not sure if I've got an employee or an independent contractor or not. This is a way of knowing when I need to get the agency or my attorney on the phone to start asking some questions. The hiccup test runs this way. If you were to fire this person, would they experience an economic hiccup, or would they go on like nothing happened? A very different situation between your plumber, who comes in and fixes your pipes, and the person who's worked for you in clerical support for the last 20 years. The plumber comes up with their plumbing truck and their tool belt full of tools. Nobody really knows what they do except plumbers, apparently. Their business cards and their sales tax license and all that stuff. If you let that person go, if you say, you know, you don't seem to know one end of PVC from another, I don't need your services anymore, that person hops in their truck, goes down the street, and inflicts their special brand of damage on the next victim. That kind of person is as an independent contractor because they have not experienced a hiccup. Their economic business goes on as if nothing really happened. Very different from your 20-year clerical person, doesn't own the PC or the file cabinet or anything about them as part of their business. All they own maybe is a picture of the grandkids up on the shelf. You come to that person and say, I'm sorry, for whatever reason, we can no longer employ you. That person is going to experience a stop, a hiccup. They're going to say, what? Wait a minute, you mean I'm out of a job? What do I do now? I've worked for you forever. I don't own anything that's in front of me, so what am I supposed to do? And those kinds of people are almost always employees. The Department of Labor got more sophisticated about it, not calling it the hiccup test, but they referred to it as calling the measuring the dependence of alleged employees on the business with which they are connected. When their economic lives are dependent on a particular business for that support, and it stops, then it's fair to say that those people are more likely to be employees as opposed to independent contractors. I ran that by the professor at USD, by the way, back then when I first started talking about the hiccup test and about 20 years ago, and she said, Marsh, that's not bad. Could I use that in my lectures? And I said, yeah, I guess you can. So it must have bubbled to the surface. Anyway, assuming we have independent contractors in our hands, about 2 years ago, the legislature passed a law that said that we needed to address clarifying the relationship between employers and general contractors in particular and subs. We were having a problem because general contractors were having audits made and discovering that payroll from subcontractors and their employees was floating on to the general's payroll coverage, and their premiums were shooting up. Insurance carriers weren't honestly paying a lot of attention. They were just saying, well, this was part of this project, there's payroll here, so we're going to start tagging it for the additional premium. The response was to establish the affidavit, which was produced by the Division of Insurance, to put out a series of questions and saying, you know, if you think that you qualify as an independent contractor, you can provide an affidavit to that effect to the general contractor and say, I'm an independent, so you don't have to worry about me. When it comes to audit time, you the general can provide this affidavit to the insurance company rather, and indicate, look, these people are not on my payroll. They've identified themselves as independent contractors. You go to them, not to me, for figuring out coverage. It is a crime on the part of the sub to misrepresent information on that affidavit, and so it provides some incentive for correctly identifying yourself. It does create a rebuttable presumption that the affiant is an independent contractor. So if it comes to us in a hearing and we have one of these affidavits provided, and the question is whether or not this particular worker is an independent contractor or not, and they've signed off on one of these affidavits, we're going to say, well, if nothing else comes up in the course of this hearing, we're going to presume that this contractor is what he says he was, a contractor, and so no coverage could be obtained. That said, the contractor cannot have any employees and still get the benefit of this. A subcontractor that employs anyone at all cannot complete the form. Now, where we run into some issues in that regard is with corporations, because as I've mentioned, most of the time, people who work for corporations are considered to be employees, no matter what their actual relationship is. If there is a service provided for pay to the corporation, we're going to look at it in those terms. So that a corporation, then, the standard one, cannot complete one of these forms. A limited liability corporation, because most of their people are members, and there's very rarely an employment relationship there, may be able to continue to say, no, we are independent contractors, we have no employees, we should be able to get the benefit of the affidavit. Now, in the past, before this affidavit law came up, most general contractors satisfied themselves for risk management purposes by getting a policy certificate from the sub saying, you have coverage, don't you? The law doesn't change that. If anything, it encourages it. The general can still insist on such a certificate for their own risk management. In the event we have a real employee on our hands and a claim is being made for benefits, the first step to figure out is whether the person had an injury that arose out of and in the course of their employment. By arising out of simply mean, was it work connected? Is there some kind of association between what this person was doing and the work they performed, including things you would naturally expect them to do, like go to lunch? In the course of refers to whether it's, in essence, on the clock. Okay, day starts at 8, ends at 5. Is that person injured in the course of that employment? Now, you need to understand that that notion gets stretched a lot in certain kinds of circumstances. The clock sort of expands depending on when and how things happen. The first such case of interest that has come up is the Voeller versus HSBC. It was a card company. There was a shooting in a parking lot in which a female employee had come out for her lunch break, and her estranged ex-husband had shot her in an act of retribution. There was no connection at all between the work that she did, the situation she was in, being in a parking lot versus somewhere else, and the fact that she was shot in the parking lot. So benefits were denied. But the Supreme Court went into some length to try to identify how such risks can be clarified and when they might fit and when they wouldn't. First of all, as far as the risk, there are those that are distinctly associated with an employment. If I work in a factory, there are heavy machines around, and one of those machines injures my arm or some other part of my body, you would expect that that kind of risk is going to be covered. There are neutral risks, or sometimes referred to as positional risks. I happen to be in a particular place at a particular time because of my work, and I get injured. The classic example is always the shooting. Somebody stands outside the building, shoots into it, bullet flies around and hits somebody. The person would not have been injured but the fact they were standing in a workstation and the bullet happens to hit them. That's the kind of law school version of a neutral risk. But for the person's employment, they would not have been injured, is the theory. And those that are personal to the employee, as was the case in Voeller, that are not covered at all. The reason they're not covered is because there is no connection to be made between the fact that a person was shot in a parking lot and anything in connection with their work. It might have been somewhat different, just so you know, if, for example, there'd been a conversation overheard out in the parking lot where the employee says, "What are you doing here?" The ex-husband says, "I knew you were going to be here at this particular time, on this particular day. It's kind of dark, so I'm going to get away with whatever it is I'm doing." And there are various features about the parking lot that make it more likely for me to shoot you. The greater degree to which that employment setting lends itself to the injury that subsequently occurs, the more likely it is that workers' compensation is going to cover. Now, the Voeller case was pretty cut and dried in the eyes of the court, but they brought out a concept of what's called increased risk in that regard. They said that the employment must add something by the way of an additional hazard to which the employees are exposed to, so that workers' compensation covers. The typical examples are the ice in the parking lot, the fact that there is a particular activity going on that will lend itself to that. If you have an area that involves a lot of heavy labor and somebody gets a heart attack, there has to be something that associates that risk to the injury that follows. All right. On the course of employment, we also have the notion that there are times when a person deviates from that employment. We have a case of Terveen versus the State Department of Transportation, in which an individual was driving a truck on the way back from a job site for the state, decided to take a side trip off on an access road because he had a side business of collecting repos for cars, and knew that this particular person was up for collection, if you will, so they were scoping out the site. In the course of going down this side road, the person lost control of his vehicle and got in an accident. Tried to say, well, I'm out and about all the time anyway, driving around, so this would be, and I was on my way back to my work site, so this should be covered, right? The problem in this particular case was that the road he chose to go by where the repo was going on was a no-access road. It was no outlet, rather. There was no way for this person to proceed on along this road and go on to his eventual site. He had to actually back up, take the car back out, and go along the road. That's often the concept is pretty similar in most workers' compensation cases. You have to be able to show that if you are deviating from a path, either that deviation is temporary or if it isn't really a deviation at all because a person would be expected to get back on the road, if you will, and proceed on. For example, in the Terveen case, we'd had somebody who had an access road and were able to go back on the interstate, say, after taking this little side path. They might have actually been able to get benefits. Now, activities are naturally related or incidental to employment. Those are covered, and usually where that comes up is when people are on the road. You have somebody who is a salesperson, for example, on the road a lot, and they're eating, sleeping, traveling to and from the job, and they get injured somewhere in the course of that. That's not a deviation. Even if, strictly speaking, the activity of eating or sleeping is not a work-related activity. Unless the employee steps aside from employment for personal reasons. The examples they give are going to a dance, catching a ball game, something like that, then there is still a connection between their work activity and the injury that subsequently happens to them. Assuming we have something that arises out of and in the course of a person's employment, there is a third test that's unique to South Dakota. There are only a handful of states that do it, that says that the work must also be, the work injury that results must also be a major contributing cause for the person's condition that results. Now, for 20 years, we waited for the courts to define for us what exactly that term meant, and essentially it worked out to something fairly simple. It says that there is no greater cause than the work injury for the worker's medical condition and or disability. My shorthand is ties go to the worker. If we've got somebody who is 50% experiencing the problem because of arthritis or old injuries, something like that, and 50% of the problem is because they happen to be lifting boxes at work, that's enough for workers' compensation to pay. If 49% of the problem is work and 51% of the problem is something else not work-related, work comp doesn't pay. It's about that bright line. It comes down to a medical opinion. Those cases are decided by objective medical information. It has to be demonstrated by a doctor to say, yeah, I think the work is a major contributing cause for this person's condition. If they don't make that statement, it may not be enough to prove it. We've had one particular case where the employee said, look, I wasn't having any problems with my knee before this happened. Now I do. And there was a specific incident I could identify that caused me to feel pain in my knee, so work comp's going to cover it, right? Unfortunately, the doctors that reviewed his case said, no, we don't have the doctors connecting the dots here. So in that case, workers' compensation didn't pay, even though you couldn't draw strictly from the inference, I didn't have pain before, now I do, enough to establish the claim. Now let's suppose we've got an employee who's been hurt already. What's the risk there? It depends on how that previous injury came about. When you've got two successive work injuries, whichever employer last independently contributed pays. Most recent in time is the one that picks it up. That contribution can be 0.00001%. Okay, so if I have somebody with who's been jumping out of airplanes for a living and blew their knee out at some point, and years later they're sitting at a desk and they get up and they feel a pop and a certain amount of pain, the doctor comes back and says, well, this isn't the whole problem, it's just a teeny-weeny bit of it, but the fact is you're getting up from the desk that day added something independent and significant to whatever was going on before. If that's the case, that new employer, that insurance company pays the freight. Okay? Now it can happen that you can return to a pre-injury state. We have at least one Supreme Court case that talks about that. So if I have my plane jumper and then they get up from their desk and they feel a pop, and at some point the doctor says, well, yeah, we know about the problem with the pop, but at some point that problem went away. It's going back to the fact the person was jumping out of airplanes for a living for 20 years. And if that's the case, the new employer and insurance company are no longer responsible. Now, if there is a non-work injury that occurs first, then you fall back on the major contributing cause test we talked about before, where you have to be able to show that the work injury was at least as important as any other cause for work comp to pay. Now, the flip side is when we have somebody who gets injured at work first, and then they have a non-work injury after that. We have, frankly, a lot of insurance adjusters and employers that get very confused about that one because they automatically assume that because somebody had some new injury that they walk away. The only test, however, is that the work must continue to be a major contributing cause for the condition complained of. And an individual by the name of Aarons in a Supreme Court case who fell through the ice while he was out ice fishing, damaged his knee. The doctor came back and said, well, to tell you the truth, I mean, I understand you had some pain a little bit from that, but the main reason you're having your knee problems is because you've got an arthritis from repetitive use that's been connected with your knee for years. And that, you know, the ice fishing thing contributed a little. The work injury part contributed a lot. So ultimately, that former carrier and that employer were held responsible, even though there was an intervening incident. Now, but it must continue to be medically connected. It must continue to be a major contributing cause for work comp to pay. And again, these things are medically decided. They must be decided by doctor's opinion. You can't just punt and say, well, this obviously isn't covered, and make up that mind on your own. Now, if we've got a real work comp claim, then there are, first of all, disability benefits that can be paid when a person has lost time. They're based on their earnings. It's usually what did the employee gross in the year before that injury. The overtime hours are paid at straight time. and there are typically no bonuses included in that unless they are non-discretionary bonuses. We've had the Supreme Court address that sort of in the last 6 months. We've had a circuit court opinion now that bolsters us in that regard, but it's been the department's position for years that if you provide a bonus that you're required to pay. Every year I manufacture so many widgets, I get a bonus for that. If I do that by a formula, by something that's set in stone, that stuff is going to be included in my benefits. If, on the other hand, I say, well, look, I'm just feeling real nice today. Things have been good for business. I feel like handing everybody a $1,000 check. That kind of thing is non-discretionary, entirely up to the employer. If that's the case, that bonus isn't included. In any case, whatever earnings you receive then become formed into the average weekly wage for the employee, which forms the basis of the benefits they receive. Now, okay, looks like we're getting back into a rising out of an course of land here. I had not meant to introduce that at this point, but it's probably worth discussing because we have a case that talks about horseplay on the job, which has to connect with the fact that whether a person deviates from their course of employment or not. In the case of Petrik versus JJ Concrete Company, this occurred during a lull at a construction site. People were sitting around waiting for a concrete mixer to show up before they could actually do anything. And they started messing around. Apparently that was pretty common in this particular workplace. They were pulling little pranks like filling up their gloves with sand and hitting their lunch boxes with junk, things like that, messing with their equipment, things like that. Such horseplay can be a deviation from employment, but only if it's serious, less likely to be considered serious. During lulls, apparently, there's a total abandonment of duty. Horseplay is not accepted in the employment, and if the horseplay was more than expected, whether it was accepted or not. Now, in the Petrik case, we had an individual who it was a hot day, like say they were at a lull, and where they weren't doing a whole lot, and Petrik's buddy was up in a cab of a semi because that was air conditioned. And the Petrik decided that looks like a good thing, so he knocks on the window and says, the boss wants you across the yard. So the guy falls for it. He heads across the yard. Petrik jumps into the cab and spends his 5 minutes in air-conditioned comfort. I started seeing his buddy coming back, knowing he's been had, and figures it's time to get out of the cab before something bad happens. So he opens the door of the cab and starts running across the construction site. Not a great idea. There was a trench that was like 3 by 5 feet. He tries leaping across the 5-foot wide trench, doesn't quite make the landing, and breaks his ankle. In that particular case, they felt that this sort of thing would be expected in a place like this because, I don't know if we call it boys will be boys or what, but this sort of lull in employment was to be anticipated in this kind of work site. And it was not anything beyond what you would ordinarily expect for the kind of horseplay that happens in a place like this. I have no suggestions for you in terms of risk management in that regard because this company had a rule against horseplay that discouraged it. They were firm saying that this is a bad idea, and they did not know about the isolated instances in which such stuff was going on. Otherwise, they would have called them on it, and it was accepted in the record that that's what they would have done. But apparently, the fact that there was a lull lent itself to providing coverage in those situations. All right, getting back to the subject of benefits and earnings. I'm sorry, I have a little bit out of sequence there. The major development in that regard is what you probably heard about already, the Voeller versus Cinnabaker's case, which says that the kind of earnings we talked about, whether from bonuses or wages or commissions or whatever it happens to be, include wages from all jobs worked on the day of injury. Now, since 1934, we'd understood the rule had been that you only considered earnings from the job at which you work when you're injured. Apparently, the Supreme Court did not agree with that. They said that any concurrent employment should be considered as far as its earnings go. Now, the legislature, with the assistance of the retailers in our office and various other players in this thing, said that that really was a misstatement of what the legislature intended. So they legislatively addressed it, HB 1084, which becomes effective on July 1st. It calls for these kinds of concurrent earnings to be included for claims incurring on or after May 6, 2015. The person has to be injured on that day or afterwards. As it happens, May 6th was the day the Voeller case was issued. So concurrent means working, not really having the expectation of employment. The example that came up in the legislative hearing was a teacher who has the summer off, and they get hurt doing the job down at the restaurant in the summer. They are not concurrently employed in the teaching job because they're not actively working in it at the time that the injury occurs. They have to actually be impaired from the concurrent job by the injury. So it's not enough that they were working two jobs, that their injury has to prevent them to some degree from fully working in both jobs for it to be considered. Not off-season or occasional day labor. They are not concurrent employment. So if I do an occasional odd job here and there as a day laborer, those jobs are not going to be factored in. And earnings are only included for the period the employee worked at the job in which they were injured. So if I have somebody who started a job, worked for them 13 weeks, and they also happen to be working somewhere else where they've been working for years, we only take a look at the 13 weeks of earnings that the person had at the job at which they were injured, not any longer period of time than that, which works honestly both ways. If we have somebody who only worked 13 weeks in the second job, we would only take a look at the whole 52 weeks in the first job. That's how long they worked. But the 13-week period is the only period of time in which we factor in how much they receive. Assuming we have a lost time claim, there are various types of wage loss benefits that are included. I'll just touch on them briefly. Temporary total disability. The doctor says you cannot work for at least a week. They are not permanently disabled yet, but they are off work. That person will receive TTD. Typically, that benefit's based on 2/3 of the gross earnings that a person had, whether in one job or multiple jobs, at the time of their injury. Temporary partial happens when a person is released to work, but on restrictions. If that's the case and they're not earning as much as they were before, but they're still earning something, you pay benefits based on half the difference between whatever they were able to make before and whatever they're able to make now. So if their gross earnings were $200 a week at their job or jobs at which they worked, and now they're coming back and only making $100, then they receive $50 a week in a temporary partial benefit. Permanent partial disability, when a person is permanently impaired but able to work. That is based on a fixed week schedule. So if I injure my arm, for example, that would be something where if I lost the whole arm, then I would receive 200 weeks of permanent partial disability benefits. If my doctor comes back and rates me for impairment as, say, 5%, then that 200 weeks is multiplied by 5% to give me 10, and 10 weeks of benefits at the temporary total disability rate is what I receive. Once those 10 weeks are done, benefits are done. And a person does not continue to receive temporary benefits after that. You just get temporary up to the point when the person turns permanent, if you will. You get those 10 weeks or whatever it is, and then they're done. There are rehabilitation wages when retraining is needed. If a person cannot return to the work they were doing before or anything suitable, they have to be able to return to work which earns at least 85% of whatever they were making an average weekly wage at the time of their injury, and they need schooling to get back to it. If that's the case, they get rehab benefits. If none of those benefits are available because a person just can't be retrained, they're too seriously injured, they're going to be off for a while, they can receive permanent total disability benefits, but they have to be able to demonstrate that they can't work at any job, even with retraining, any single job, mind you, that earns at least their temporary total disability rate. So if that rate was $400 and they can't make $400 a week, they get perm total. And of course, there are death benefits to the dependents or supportees of an employee when they die on the job. There are maximum and minimum benefits. Those are set on the worker's date of injury and do not change. The maximum is the average weekly wage for all South Dakota workers for the year leading up to each new July 1st. So right now, the maximum benefit is $733 a week. As of July 1st, that will boost up to, I would assume, another probably closer to $750, something like that. The minimum is half the state's average weekly wage, rounded up to the nearest dollar. Right now, that's $367. But if the worker's average weekly wage is less than the minimum, less than this $367, benefits are figured using net wages, wages less weekly federal and state standard deductions. All right, medical benefits. The employee can receive, they have their first choice of provider, so they get to see whoever they want. An employee, however, can acquiesce in the employer's choice of doctor. So if you tell them, look, I've got a good relationship with Dr. Jones down the street. I want you to see him when you get her on the job. You can't force them to do it, but statistically we've seen between 80 and 90% of the time that's where the employee is going to go. And if that's the case and they start to treat with that doctor, they have then acquiesced that employer's choice. So they can't come back and say, well, now I want my choice because they've made it. Okay? There's no change in that chosen doctor without written approval from either the employer or its insurance company. So once they're in with this chosen doctor, even if they don't like the care they're getting, that's where they continue. If the employer refuses to make treatment available, the employee can go looking for it wherever they want. So if the employer says, well, I know you treated with Dr. X, but we're not going to pay for them anymore. You might still need it. We're just not going to pay for it. Then the employee says, well, I can go to any doctor I want because you've left that door open. You're only responsible, however, for necessary, proper, and reasonable care. What the treating doctor says is presumptively correct. It's what it says goes, unless proven wrong by the insurance company or the employer. So if the doctor says, yeah, I think you need chiropractic treatment for the next 50 years, and there's nobody to contradict them, that's what the employee gets. If there is necessity versus, there is the issue, however, of necessity versus convenience. And this comes up repeatedly the more seriously a person is injured, it seems like. You do not have to do things merely for the comfort or use of the employee. They have to be connected with a treatment goal that the doctor has set. For example, where it typically comes up is with modifications to a home or a car for someone who is significantly enough injured to require a wheelchair. Okay? There are things that are conveniences. I should be able to get a ramp to get out of my house. That's a necessity, but it is a convenience if that ramp is located in a particular place. It requires you to significantly remodel the house to do it. It would be nice in a multiple-story house to have an elevator to get up and down, but it's not really a necessity. There is no medical reason why a person would necessarily need that. And those are the kinds of issues we address. There is utilization review that's available and medical case management. Most carriers these days assign case management nurses to cases, and they have a right to have a say in how often a person is treated, how often they treat, what they treat, and whether they're making referrals or unusual diagnostic tests. And as we see also frequently, the independent medical examination. The employee has to attend an examination assigned by the insurance company or the employer, or their benefits are suspended unless that particular exam is not reasonably convenient, which we read pretty narrowly. By reasonably convenient, it means would this person's physical condition actually be made worse if they're not able to, if they attend this examination, or if they schedule the examination for the next day and the person is clear on the other end of the state, things like that. But ordinarily, if the examination is scheduled, the employee is required to show up. And if they don't get there, their benefits are suspended until they do. It does have to be by a South Dakota licensed practitioner, and you cannot request that examination more than once a month after the first one's done. Benefits can also be denied for misconduct. Intoxication or illegal drug use on the job that causes the accident is a basis for denying benefits. So do your homework as an employer. It's not enough to merely rely on the insurance company to do the investigation. You can do drug testing. You can investigate with witnesses to see what this person's behavior was like. Failure to use required safety devices or follow safety rules. If the employer sets the rule and they get pretty insistent about how they get followed, the employee has to follow them. And if they get injured because they fail to do it, they don't get benefits. Breaking the law. Potentially things like using seat belts or speeding, or in one particular case, leftover Valium, may be a basis for denying benefits, but there has to be first a connection between that and what ultimately happens, and that rule has to be fairly vigorously enforced by the employer. The employer must have a rule that says you got to wear your seat belts every time. You do not get to speed while you're on the job. You're violating our work rules if you do. And you have to be able to show that misconduct, whatever it is, actually caused the accident. Post-injury negligence, the classic case of that is a person who broke their hand in a work injury. That night they decided to go to one of these spend 30 seconds with a champ boxing matches where they're swinging at this guy. After about 5 minutes, the particular employee broke their hand again. That kind of negligent behavior post-injury snapped the connection between the original injury and whatever condition resulted. So benefits could be denied. Now, important thing to keep in mind with all these examples of misconduct, it must be shown to have been a proximate cause of the injury. Okay? It's funny how I've given an example of a wrecking ball at a construction site for years, and it turns out that if you go on YouTube now, there's actually an example where you can see this in action. There's a minivan in the video going through a construction site, and suddenly out from the left comes this gigantic wrecking ball that smashes into the minivan and bumps it over about 30-40 feet through the air. Now, of course, being the work comp guy I am, I always ask myself, would this make, how would work comp apply in a situation like this? Well, let's suppose, for sake of argument, that the driver of the car has been smoking pot all day. Okay, they're driving the car. Would it really make much difference if they flunk a subsequent drug test as to whether work comp pays? Probably not in most cases, because whether the person was sober or stoned out of his mind, if he gets hit with this wrecking ball at the time, and that's what causes the accident, it's not going to make any difference. Your wrecking ball kills even if you're sober. Okay? It might be different, however, if when you're interviewing the witnesses in the van at the time this accident happens, what they say is the guy saw the wrecking ball coming, and he looked at it and maybe waved at it, gave me a friendly smile and saying, oh, that's a nice wrecking ball, as the ball smashes him off into the great beyond. Then it's clear, at least potentially so, that there's a case to be made that the use of the drug had something to do with the accident. And it's going to take probably actually medical testimony to be able to confirm, yeah, wow, if this guy had been sober, he would have avoided this problem. But it takes that extra step. So just the fact that the person flunks a drug test, not necessarily enough. Okay, now employees have to provide notices of their workers' compensation claims. They're required to do that within 3 business days after they reasonably conclude that A, they got hurt, B, it happened at work, and C, where we see the most issues with this, it's serious enough to report. It's comparable to the standard for employers where they have to show that there's something involving more than minor first aid. If a person knows or should know that they're going to lose time from work or that they're going to need some medical treatment as a result of something, it's serious enough to report. Now, we get a lot of questions about repetitive use injuries, carpal tunnel, for example. When does a clock start for those? Well, there's a difference between a person sitting at a desk, clicking along on their keyboard and saying, fingers kind of sting a little bit. And later on, waking up in their bed and realizing they can't feel their hands, and they've been feeling some pain off and on for a while, and then they need to go see a medical treatment for that. The first case, they don't need to report it, really. In the second case, they are required to. Okay? Now keep in mind with the notice requirement that the employer need only have actual knowledge of the injury, no matter where they get it. So if a coworker comes up and says, I think John has been showing some signs of carpal tunnel lately. He said he was going to go to the doctor today because he thinks it happened at work. That's probably enough to get in the door. The threshold for what constitutes actual knowledge for an employer is pretty low. All it's needed is for an employer to think, well, maybe I should look into this to see if this is a work comp deal or not. And if it is, that's enough to establish actual knowledge in the minds of the courts. So the fact they don't necessarily give you a piece of paper doesn't mean much. But as on the flip side, if they come back a year later and say, oh, remember this happening a year ago, and none of your people have any recollection of it, and there's nobody who witnessed it, those kinds of things are probably not going to get paid. Enforcement. The Department of Labor has several functions in regard to all of this. First of all, an employer and insurer can be fined if they do not timely report this claim after they find out about it. It has to involve more than minor first aid, and if they don't report it when they know about it, it's a $100 fine. The insurer has 20 days to investigate the claim from the time they receive it, or they can be fined $100. They can ask for more time to investigate it, up to 30 days, so they can get up to 50 days to look at it, but they do have to ask. For any benefits that are more than 10 days past due, disability benefits, not medicals, 10% penalty can be assessed by our department. We do that occasionally. As far as monitoring the activity of employers and insurers in that regard, we have monthly reports that require insurance companies to submit by the 16th of the month after the month in which the benefit was paid. All right, now we have various dispute resolution processes available in the event. First of all, the main one, we have informal assistance to anyone who asks. Okay, if you call us, it's not like the IRS where we come back in the next week and do something nasty to you because you let us know about your problem. Okay, instead, we hope just to be able to address whatever concerns you have informally, whether as employees or employers. We have a mediation process available that's almost always on the phone. We do about 50, 60 of those a year, where the insurance company, typically an employee and me, get on the phone and try to work out some kind of informal settlement of their dispute. And of course, we have the formal hearing process, started by filing a petition. Form is available on our web page for that petition for hearing. The hearings are held, they're due process hearings with attorneys typically on both sides, held where the injury occurred. And we also have a declaratory ruling process that's available in the event that people have questions of wide public concern that we need to address. And we can do a hearing and subsequent ruling on those issues. One closing for my comments anyway, I certainly wanted to leave time for questions, hope we haven't run too long here, is the case unique to me. It's the only one of its kind I have ever seen, so I wanted to definitely bring it to your attention. The case of Dakota Trailer Manufacturing versus United Fire and Casualty, or yes, you can fight City Hall. In that particular case, an insurer audit changed a category, classification for workers at Dakota Trailer from machine shop workers to welders. And apparently there's a rather significant premium increase connected with that change. Dakota Trailer said, hey, these folks are machine shop workers, they're not welders. So they complained to the insurance division and NCCI, which is a database assistant for the insurance division, a national organization that sets the filing techniques and manuals for which these classifications are created. And both of them agreed with the insurance company. That matter was appealed to Circuit Court and then to the Supreme Court. And in the Supreme Court decision, they took a look at the so-called Scopes Manual, which is used by NCCI in establishing these rate classifications, and these employment classifications rather, and said essentially NCCI and the insurance company misinterpreted their own documents. So the premium increase was reversed. They went back to calling them machine shop workers after that. Now, I say to my knowledge, that's the first time any state in the United States has ever had a Supreme Court level case that talked about the employer getting a decision reversed on the part of an insurance company about how to classify our workers. But we get lots of questions. The insurance division gets a lot more, and I guess you just need to know that that process is available, and once in a while, it actually works. All right, with that, I just wanted to let you know, this is our contact information for the department. Bonnie Ackerman is our work comp compliance specialist. I like to think of her as work comp triage. The everyday kinds of questions that you have, she's more than happy to answer. And I, as the director, you know, I'm not like, we're not Minnesota here. We're not some other state where you decide you know, we can't call the big cheese. I'm here the same as anybody else to respond to your questions and concerns. With that, I want to leave time for questions. Thank you so much.
James, thank you. It was an excellent presentation as always, and I want to echo what James just indicated, that he is a tremendous resource, as is everyone within the department over there. Anytime that our members or our staff have questions on these or any other labor-related issue. And so appreciate your time, James, today. We're going to go ahead and get started with some questions. And before we do that, I'll remind everybody that if you have a question, go ahead to the panel on the side of your screen. You may need to click on that orange arrow to maximize the panel. And where it says type message here, type in your question and then click on send. We've got several questions already, James, and I'll try to get to them. Let's start with the first one. Would you please clarify the situation regarding a contractor? If a contractor's employee is injured while working at our company and the contractor does not have work comp coverage, does that make our company liable?
Short answer is yes. If the law specifically calls for a contractor's employees when the subcontractor is uninsured, working at the same job site under a project for a general, that sub's employees can make a direct claim against the general for benefits and work comp.
Any helpful advice to an employer, James, or a general in that situation of ensuring that their sub has coverage?
Well, a couple of tools there. First of all, you do have the affidavit available that can distinguish them as subs, and they aren't supposed to have any employees if they complete the form. That's why the affidavit's important. So you can at least reduce the possibility you've got some unexpected workers out there. The other part of it, of course, is that, yeah, you have every right to go to your sub, even if they don't have any employees, and say, we've got to have a policy certificate for you for covering our own back ends. So no harm in asking.
James, could I have you, before we go to the next question, go to your previous slide that has your contact information? I want to just make sure we have that up. Thank you.
Problem.
Let's go on to the, oh, go ahead. Let's go to our next question, James. In regards to the employee earnings, if there are commissions involved and the employee receives 10% of department gross earnings, would those commissions be considered non-discretionary?
Informally, I would say yeah. There's a strict formula that's used to calculate those earnings. As a rule of thumb, what we use in a situation like that, could the employee sue if they didn't get it? That's kind of a nice little litmus test for those. And we would be inclined to think, yeah, if the employee doesn't get that benefit, it's been explained that that's how they get paid, they're going to come back and potentially file suit against the employer for that. So that's the kind of non-discretionary earning that they should include.
James, how does the second job issue work if the full-time employee has his own side business as a subcontractor? Are you responsible for his or her lost income from that subcontracting job?
Keep in mind that it talks about concurrent earnings in employment. Okay, so in this case, when you've got the sub, they're not working for anyone, they're working for themselves. So in that case, no, those kinds of earnings would not be included.
Next question. If an employee is injured from their home and came to work because they needed the money and not cleared from the doctor for work, what is our liability? The job is mostly clerical.
Well, initially, you take a look at it as, did this person get hurt at work? Was the work a major contributing cause to their condition? And probably in those two cases, yeah, that's the case. Now, there is a limit to that. That was explained when we mentioned, I think, the post-injury negligence matter. Let's suppose you've got somebody who had a back injury, say, and as a result, this is from a real Supreme Court case called Welch versus Automotive Insurance. In that case, the person had one of those BAK thermite, good grief, titanium cages put in their back because their vertebrae had been so messed up. And the doctor told him, look, you're only supposed to be lifting 20 pounds, okay? Otherwise, you're going to have a problem with the cage. Well, this person was out there lifting like 100-pound car hoods, and basically that poor little cage just got squashed. So then they were back, and they had a much more serious injury. In that case, that kind of post-injury negligence was held attributable to the employee, and work comp was not responsible because they engaged in that kind of serious negligent conduct, gross negligence that would take it beyond the pale of the usual work comp claim. Now, it would be very different, I think, if Mr. Welch had lifted like 25 pounds, for example. I mean, you know, you're not really looking at negligence there, just kind of pushing the envelope a little.
Okay, our next question, James, we might need some clarification from the individual that asked. How does the 3-day business rule apply to RMIs? And I'm not sure if I understand what an RMI is. I don't know if you do, James. So if that individual that asked, they could just send us an email back in or a question back in, we'll try to get that clarified.
Sure, yeah, I'm not familiar with that term either, I'm afraid.
Okay, let's move to the next question then. Are employers obligated to pay for the time missed to go to the doctor's appointments, physical therapy appointments, etc.?
Wow, that's a tricky one because the law does not address that very much, but we do have a policy we've developed over the years in connection with it. You have to get over a number of hurdles first. First one, before I get into those, understand that if the employer sends the employee to the doctor and says, you will see Dr. X, okay? The Fair Labor Standards Law, I'm not part of work comp at all, but the Fair Labor Standards Law says that is paid time for figuring like the minimum wage and overtime. So if I'm saying you have to see this doctor, that's paid at least $8.55 an hour, okay? Now, as far as work comp benefits go, there are a number of things you have to consider. First, you don't get any disability benefits, lost time benefits, unless you meet the waiting period first. So if this person hasn't been a week off work, they don't get anything for the doctor visit, okay? We have lots of people missing 2 days here, 3 days there, and you know, they want their time paid. It's not a requirement. Second step would be that the person has to show that their time off is directly a product of their work injury. If they decide that they're going to drive to Sioux Falls and they live in Pierre, and they can get the same treatment, say in Pierre or someplace closer, maybe not as much of that lost time is going to be covered because they can't show it's connected with their injury. If they have already been rated for impairment, and this happens a lot, we have somebody who was on temporary benefits for a while, then they go on permanency because the doctor rates them. They come back and say, well, now I want time off benefits. Well, those time off benefits stop, as we mentioned earlier, when permanent benefits are paid. So unless that person can show that there's something new going on, something significant from whatever they had before, they probably aren't going to get benefits of any kind after that permanency is exhausted, whether for doctor's visits or anything else.
James, we're going to jump back up to that previous question. How does that 3-day business rule apply to repetitive motion injury?
Ah, okay, yeah. And we touched on that briefly when I mentioned the example of carpal tunnel. You have to get to the point where the person knows that they are going to need, or should know, that they were going to get medical treatment or that they were going to lose time from work, because then it becomes serious enough to report. Our courts have said that it's only when that happens when the light comes on and the person needs to file the claim.
James, are we obligated to file a claim for an injury that's reported after 3 days from the date of injury?
Yes. Yep, well, we see a lot of instances in which employers try to be gatekeepers for their claims, and they say, well, I know you're not going to get paid for this one for whatever reason, so we're just not going to file it. That's a bad idea. All that happens is that you make 2 wrongs, and you know what happens. That never makes a right. So whether it's misconduct or notice or whatever reason that they think is not, makes it an invalid claim, let your insurance company handle it, bottom line. Send it off to them. Let them make the decision that there was no coverage, there's a misconduct or notice issue, whatever, and then let them deny it, then you're safe.
With the release of the affidavit July 1st, 2015, and the subcontractor signed it, it states not one item on the affidavit is controlling. Why then are we being held liable if the subcontractor meets all items, but the item we as the contractor have subcontractors being considered an employee?
Keep in mind that, keep in mind that while the affidavit rule helps you with premium issues, trying to allocate who pays what, it does not change much any of the laws concerning liability when somebody finally does get hurt. The affidavit doesn't do that, but the only respect in which it does is to create the rebuttable presumption that the person is a contractor instead of an employee. Okay, but when it comes to those persons' employees, this law and this affidavit have no impact on them at all. It doesn't change those rules. All it does is to say, well, at premium time, you can pick out, with some planning, who are your subs and who are your generals.
We've got time for a few more questions here, James. How can an employer be aware of concurrent earnings from another job?
Well, the law goes into that somewhat. As of July 1st, it says that an employer and an insurance company has the right to make an investigation if the employee comes forward with it, and to find out what earnings were received, what kind of periods of time we're talking about, what kind of work they did, because it would have an effect on, if they were impaired for one type of job, not another. Now, trying to be the prophet, if you will, trying to figure out, if a person is engaged in such employment before they get hurt, that's a little trickier. But there's honestly no law that prevents you as an employer saying, say, are you moonlighting anywhere? Some employers say, we have a rule that says you will not be allowed to moonlight if you're working for us. Okay, you have every right to do that if you want. But certainly you have a right to ask. There's no violation of any discrimination law or other employment law in saying, you were supposed to tell us about this. And then they have an obligation to do so, I think, as a condition of keeping their jobs.
An employee said he was injured at work on Monday morning. No one saw it happen. I know he was involved with a sports event over the weekend, and I suspect that's where the injury actually occurred. Is there anything I can do?
Well, keep in mind that there is no physician-patient privilege when it comes to workers' compensation claims, at least as far as the employer and the insurance company go. So if you know the doctor that this person is treating with, it's certainly within your rights to contact the doctor and say, look, I know you're the one figuring out whether or not this claim is work-related or not. You ought to know that I think this person was sliding into second base on Saturday afternoon, and maybe that's why they're in there to see you. So you can cover yourselves a little bit. If nothing else, you can let your insurance company know that, and they can ask the nasty questions. Because ultimately, the buck stops with the doctor. The doctor's going to say, yeah, it's work-related or it isn't, but they can't make the right opinion if they don't have the full facts.
James, it appears we have one last question, so we'll get to it. You probably covered this already, but if so, I missed it. Does the state law require me to carry workers' compensation insurance? And what happens if I don't?
Yeah, I haven't actually covered that one. It's a very, very interesting question because it depends on what you mean by required. Okay. Now, technically speaking, there's only one state in the country that doesn't give any penalty to an employer if they don't have the coverage, and that's Texas. Now, every other state except ours says if you don't have the coverage, we can shut you down. We can fine you. We can penalize you in some way by making a payback additional premium or some such thing. In South Dakota, technically it's as compulsory as anywhere else, but our penalty is more limited. The state will not get involved in whether or not you're insured. Okay, so in that way, no, it's not required. But if somebody gets injured on the job, then they can make a claim against you in the courts, which work comp shields you from, by the way, for twice the disability benefits work comp would have paid, plus all your medicals, in no fault. That's where the rub comes. You don't have to prove that the employer did anything wrong. All you have to prove as an employee is that I was working, I got hurt, this is what happened. Now, might not seem like a big deal, but in the last 10 years, we've had at least 8 claims reported to us through the insurance industry that were at least $2.5 million a piece, catastrophic claims, and one was $13 million. Now, I can tell you, there's nobody on the phone today that would go uninsured and survive that kind of a hit. Not going to happen. So that's why you have the coverage.
Well, James, I think that concludes our questions for this morning. Are there any wrap-up comments that you might have?
Well, just I very much appreciate your willingness to have us involved in this today and putting this together. It's really gone very well, and I've enjoyed it.
Well, and I would remind everyone that's on for Jim's contact information there for the Division of Labor and Management, Bonnie Ackerman and James. Again, James, thank you for all that you do to be a great resource for our organization and our members.
Thanks, Sean. Appreciate it.
Just a couple of wrap-up comments. You probably all have heard of the new U.S. Department of Labor information or proposed rules on final overtime. That information was released yesterday, and if you go to SCRA's website, you get information about those new overtime rules, and we'll continue to be pushing information on that as well out to our members. This webinar was recorded, and a link to the recording will be emailed to all of you later today. We have several other webinars scheduled over the next month and a half. Those topics include information on how to reduce shipping expenses for your business, employer support of the Guard and Reserve, as well as the rights and responsibilities of employers under the Uniformed Services Employment and Reemployment Rights Act, and the first steps to take when hiring employees who have disabilities. That's part of an important project, an initiative that SCRA has taken on this year called Getting Down to Business, and you'll be learning more about that over the months ahead. Check out our website for details at www.sdra.org, and under the Training tab, click on Webinars and Seminars. We will also be holding employment law workshops in Watertown, Sioux Falls, and Rapid City this coming September. Be sure to watch our website and newsletter for more details. With that, James, again, thank you for your time, and thank you to all of you for participating in today's program. Have a great day.
Thanks, you too, Sean.